In the courtroom, it's where a lawyer really becomes an actor. There's a very fine line between delivering a monologue in a play and delivering a monologue to a jury. I've always felt that way. I've been in a lot of courtrooms. The best lawyers are really theatrical. Woody Harrelson.
The federal building's large ceremonial courtroom, reserved for show trials, is veneered in executive teak. Bench, counsel tables, jury boxes, entrances, and exits all are as formally arranged as an Elizabethan stage. Only the drama is shapeless, at least to those of us who have never seen a trial before. We see only random movements, sequences, comings and goings, no form or agenda apparent. To us, the action is less like watching a play than watching an aquarium.
Defense counsel Adam Allen presented the opening statement for Mr. DaCorta's defense. Mr. Allen had worked with Mr. DaCorta for more than 2 years preparing for this trial. They and their witnesses generated 336 exhibits, but defense counsel only submitted 103 of them into the trial. A company balance sheet was not among them.
Each lawyer will stand up, and if he knows what he's doing, he'll say, here's what we're going to do in trial. Here's what we're going to show you. And we're going to bring forth evidence that's going to show this, it's going to show this, and this. Now, the other side is going to say this, this, and this, but we're going to show that's not true, however they do it. Right. So you tell them, you give them a roadmap, you tell them what you're going to do. You try to get them interested. Because if they're the biggest crime you could commit in the trial is to bore the juror. He won't like you for it. You got to keep things moving if you can and tell a story.
In his heart, in his mind, and in his soul, the evidence will show that my client was always trying to succeed. He was never acting with the intent to deceive. To be able to establish the allegations they have lodged, the government will have to establish beyond a reasonable doubt that Mr. DaCorta was acting with the intent to defraud. The court will instruct you that under the law, intent to defraud means the specific intent to deceive or cheat someone, usually for personal gain, or to cause financial loss to someone else. As such, in order to find Mr. DaCorta guilty, the government will have to prove to each and every one of you beyond a reasonable doubt that he was trying to cheat someone out of their money. If the evidence therefore shows that Mr. DaCorta was not trying to cheat his investors and lenders for his own personal gain, but instead was striving to make them money, then reasonable doubt will exist, and he was not acting with the intent to deceive or defraud. It's a simple case because it's all about his intent. Was he involved in a scheme to defraud, or was he involved in a misunderstood complex business, misunderstood by the government regulators, misunderstood by the FBI and the IRS, and ultimately misunderstood by the U.S. Attorney's Office? The court will instruct you that reasonable doubt is a very heavy burden of proof. In fact, it's the heaviest burden of proof that we have in our criminal justice system. The court will instruct you that a reasonable doubt is proof so convincing that you would be willing to rely and act on it without hesitation in the most important of your own affairs.
He said you'd have to rely on reasonable doubt as proof without hesitation. What does that even mean?
So, after the government is done presenting its case and you hear from our case, if you're not quite sure, that is reasonable doubt. Reasonable doubt is exactly what it says. The government has to present sufficient evidence that you have no doubt that is unreasonable.
I don't understand him.
A lawyer once told a jury that the person his client stood accused of having killed was about to walk through the courtroom door. When the jurors looked startled, the lawyer asserted that if those jurors had wondered, even for 1 second, that the victim might appear, that belief constituted enough reasonable doubt for them to find his client innocent.
Reasonable doubt will exist in this case because the evidence will show, and the government will be unable to establish beyond a reasonable doubt, that my client was acting with the intent to defraud. Because the evidence will show that my client was acting with the intent to defraud. That he was acting with the intent to cheat or deceive someone out of their money, because there will be a lot of evidence that will show that he was acting with the intent to succeed for himself, for his family, for his investors, and for those who had a financial stake in his companies. The government will attempt to persuade you that Mr. DaCorta was living a lavish lifestyle in this incredibly fancy house. But the evidence will show that while Mr. DaCorta and his wife and his college-age daughter were residing in this particular residence, that this was just one of 11 investment properties that his company owned. He lived there, but it was not owned by him. It was an asset of his company.
Incredibly fancy house Mr. Allen referred to, located at 13318 Lost Key Place in Bradenton, Florida, is identified by the arrow in this aerial photo of its neighborhood. Isn't it rather overstated to describe it as incredibly fancy, when it's obviously surrounded by hundreds of others of the same size and scale, or even larger?
The government is going to spend a lot of time talking about the 3 vehicles that Mr. DaCorta was purchasing, that he was driving, that his wife was driving, that his daughter was driving, and vehicles that were owned by other people that worked at his company. And they are going to show you a picture of all the vehicles that they seized, and they are nice vehicles. But this case isn't about nice vehicles. Nor is this case about the fact that my client took a vacation with his wife of 34 years to Italy. Nor is it about that he used the money he was earning to help subsidize his daughter's education. Nor is this case about the fact that Mr. DaCorta started a business with one of his sons. Nor is it about that on occasion he used a private jet for family and business purposes. The government is also going to talk about a holiday party, 2 holiday parties that his company had in 2017 and 2018. And they are going to likely talk about that. They had a band and they had ice sculptures and they had a Santa Claus and they had nice food. All of these matters that the government is going to spend a lot of time on during this trial is nothing more than a red herring designed to make you not like my client because he drove a nice car, because he was living in his company's home, which was nice, because he had a Christmas party for the people that were investing in his company.
If you know what the trouble is, I wish you'd please tell us.
None of these have to do with the 3 allegations against him. And what are those 3 allegations? The first is that the government has alleged that my client participated in a conspiracy to commit wire and mail fraud. Second, that he was involved in an illegal monetary transaction. And third, that he made a false statement on his 2017 income tax return. We believe that the government will not in any way be able to establish beyond a reasonable doubt that Mr. DaCorta was in a conspiracy and a partnership for crime with other individuals.
Did you ever see anything put together worse than that?
The government has alleged, and they talked about it in their opening statement, this allegation that Mr. DaCorta was involved in a Ponzi scheme. And so, let's talk about what a Ponzi scheme is.
Well, it's downhill from here.
On your screen, you'll see a legitimate investment opportunity. There's a group of investors. They are provided an investment opportunity. They invest their funds in that investment opportunity. The investment opportunity is profitable, and the profits are returned to those investors. A Ponzi scheme occurs when there is no real investment opportunity. They're just being told that there's a real investment opportunity, and in their being told that the profits or dividends that they are getting from that investment opportunity is coming from this real investment opportunity, when in truth and fact there is no real investment opportunity. And a Ponzi scheme occurs when the first group of investors are being paid their profits and dividends in truth and fact from a second group of investors. So, what is key in determining whether or not there is a Ponzi scheme is there's no real investment, and the first group of investors is being paid alleged profits from a second group of investors. The evidence in this case will show that Mr. DaCorta was not involved in a Ponzi scheme. Certainly the government will not be able to prove that beyond a reasonable doubt, because what the evidence will show is that Mr. DaCorta and his companies had an investment opportunity. And the group of investors provided funds towards that investment opportunity. And those funds were deposited into the operating bank account of his companies, and a portion of those funds were put into this investment opportunity. And that investment opportunity generated revenue. It was producing income, but that revenue was not deposited back into the operating bank account, but instead was put back into the investment opportunity. And then, when this group of investors got a return on their investment, those funds came out of the operating bank account.
The jury just heard a word salad. In just 6 short paragraphs, Mr. Allen said investment 16 times and opportunity 14 times.
I wish they had done that differently.
How would you want them to do it?
Better?
The definition of a Ponzi scheme is an investment swindle in which some early investors are paid off with money put up by later ones in order to encourage more and bigger risks. Merriam-Webster Dictionary.
What is key in focusing on whether or not Mr. DaCorta was involved in a Ponzi scheme is whether or not there was a revenue stream that was generating sufficient income to pay his investors separate and apart from any money from subsequent investors. We believe the evidence will show that Mr. DaCorta's business was not a Ponzi scheme because there was a real investment opportunity. That real investment opportunity was generating nearly $50 million of revenue. And that revenue was sufficient separate and apart from any money provided by subsequent investors to repay the first group of investors.
Now, why didn't we think of that before?
The penalty for laughing in a courtroom is 6 months in jail. If it were not for this penalty, the jury would never hear the evidence. H.L. Mencken. Let's review what defense counsel Adam Allen emphasized in the first part of his opening statement. He said the government would have to establish beyond a reasonable doubt that Mr. DaCorta was intending to defraud, but unfortunately he failed to adequately explain what reasonable doubt is. By failing to give the jurors a lucid understanding of this standard for criminal conviction, the fact that only in the complete absence of any reasonable doubt could a vote to convict be valid was left obscured. Thus, he may have exposed his client to the whims of a jury more easily persuaded by the prosecutor's wholly unfounded entreaties to send Mr. DaCorta to prison for presumed crimes he did not commit. Mr. Allen did not clearly explain that to obtain a conviction for fraud, it was essential for the prosecution to prove that Mr. DaCorta intended to cheat and steal. Instead, he left the jury to determine for themselves that Mike had no such intention from inferences sprinkled into the opening statement. Mr. Allen affirmed that Mr. DaCorta's sole intent was to succeed, and stated his belief that the government would not be able to prove that Mike conspired to defraud. Finally, defense counsel noted that lender funds were deposited in Oasis's operating account, but its earnings were retained in the investment opportunity. Due to the incomprehensible rambling discussion that preceded this statement, it could only be received as a non sequitur when Mr. Allen added that lenders were paid out of the operating account. He was probably trying to distinguish that the operating account was used for daily operations while earnings in from trading and sales were retained in the trading account. But the importance of this point was totally lost in the confusion of words used to deliver it.